Welcome to the Hard Questions. My name is Raymond Mujuni. Few Ugandans have had an illustrious career in the public service, as our guest today has had, serving both in the executive, the legislature, and the judiciary, and at the apex of all those. Today, our guest for the Hard Questions is Chief Justice Emeritus Bart Katureebe. Thank you so much for hosting us and for allowing us into your home.
Thank you. You're welcome.
Yes. Let's start with, you've written such an illustrious book of your time in all the three arms of government. What was the torturous process like writing this book?
Well, I just felt that having served this country in various aspects, I also owed it to not only to myself, but to my children and friends and the people I've served with to see who I am, where did I come from, what were the various stages I had to go through, how did I get to serve, and a little bit of how I served and how I got off. So I felt I owed it to quite a number of interested parties.
It's pretty unique for your time in civil service, and I struggle to actually find a Ugandan who's had a chance at the apex in the executive, in the judiciary, and in the legislature. How did this happen for you in just 6 decades?
Well, I think a bit of it is a bit of luck, I think, providence. I don't know if it is also hard work and wherever you worked, the record you left behind. I started in the civil service as a state attorney. And within a few years, I had gone through several promotions from where I joined as a pupil state attorney to a principal state attorney. And I decided to resign and go and try it out in private practice. But it is also, I don't say it for myself, but many people believed that I was doing well as a state attorney and would not have wanted me to leave. But I reached a point, I said, well, once I'm a principal state attorney at that time, the avenues for promotion within the Ministry of Justice were very limited. What else could I be? There was one position for maybe director and then solicitor general. I didn't see that as an opening for me. So I went into private practice. And I tried it out, I think with some degree of success.
A large degree of success. The biggest law firm in Uganda. It can't be
with some degree of success, because at least I managed to attract the attention of my colleagues, both lawyers, the judges. You know, you get to be characterized as this one is a good lawyer or is an upcoming good lawyer. I was very young at the time. So there was that. And then out of the blue, an announcement came on the radio that I had been named a deputy minister. That was 1988, when I had been in private practice, I think about 5 years. So then you go and serve there. And I assume that the people I served with and the appointing authority must have been satisfied with my service in that capacity, because I was able to remain in government, first as a deputy minister for several years in the various ministries. I started with regional cooperation, foreign affairs, industry and technology, health, and eventually, after the making of the Constitution, I was appointed Minister of Justice and Attorney General. I suppose someone must have looked at my work, my contributions during the constitution-making process and so on. So, and I served as Attorney General for the next 5 years. And at the end of that period, I said, well, okay, I can't go higher than this. I was dying to go back to private legal practice, because by then I had served 13 years in government. And I went back to private practice, formed Kampala Associated Advocates with a number of colleagues. And 5 years down the road, a call again, initially by the Uganda Law Society, we want to nominate you to be our nominee to be appointed to the Supreme Court. So the rest followed from there. So I ended up in the Supreme Court, and as you know, the rest is history.
The rest is history. Your life has interlocked with public life a lot. In fact, we can, with varying degrees, claim you as a public official, less as a private individual. What would you say are what is your most iconic moment in public service, in the growth and development of Uganda? What's that one iconic moment you say, this moment stood out for me in my years?
I think the making of the Uganda Constitution, having been elected a Constituent Assembly delegate for Bunyaruguru, and having been elected by the Constituent Assembly on the Legal and Drafting Committee, the day we made that Constitution and the day I signed the Constitution was an iconic moment for me, because I really felt, as a lawyer who had studied constitutions and so on, I felt this was the highest point in my life as a lawyer, to have participated in the making of the Constitution for the country, and participated in the debates, participated in the drafting, and now signing it. And I remember I used to have a copy of the photograph I took holding the new Constitution after signing it. And I was using it as one of my campaign pictures in the following campaigns. So this was my highest moment, and I would go and defend the Constitution.
When you look at that Constitution now, pretty much in retirement, does it strike you as the same document? Does it strike you as a functional document that has wielded the power and force to build Uganda into the one that you have loved to see?
Well, things have changed. I think certain parameters, certain considerations upon which some of the decisions we made were made have changed. What is important is that the Constitution allowed itself to grow and to be amended as times changed, as society required. So whether the amendments that have been carried out are within that context is something that you can debate. But certainly the Constitution did not see itself as static. It saw itself as a living document that could change, that could be amended. And we only hope that the amendments that were initiated and have been carried out were in that context.
In regard to the amendments, and particularly in inculcating constitutionalism, how do you feel the country has fared? Or where do you think effort should be applied?
I think generally, the Constitution is holding. Generally, so it's holding. There were contestations on the amendments that have been made. I don't think we can go into that now. But the Constitution, in terms of setting up the three branches of government, in terms of having a working parliament, a working judiciary, the working executive, have generally been in place. There are still a lot of teething problems, as I'm sure you would expect in any new constitution in an emerging society like ours. There are still people who do not understand their roles. Be it in the executive, be it in parliament, be it in us in the judiciary. There are sometimes overlaps. It's, for example, when a court makes a decision. Now, you would expect that under the Constitution, someone is not happy with this Constitution, you appeal to the next level. That's why the Constitution provided various avenues of appeal. But when you hear that a judgment made by a judge of the High Court may not be enforced until an RDC has approved it, then you have a problem there. Because what are the resources, be it financial, be it academic, be it manpower, does an RDC have compared to what is at the disposal of a High Court judge to make a decision? Who has had the witnesses, who has studied the law, he has had people research for his judgment and so on. So you get that overlap. But it also puts strain and pressure on us in the judiciary to make sure that the decisions we make are transparent and they are understood by the public generally. So when we get to be misunderstood, then you sometimes get this overlap. Now, those are teething problems, I think, within the Constitution.
You see, Chief Justice Emeritus, some of these teething problems are not just small problems. You've mentioned the RDC example. That aside, I remember when you were Chief Justice, you used to complain about if we make a judgment on bail and someone is granted bail, I don't want to see people grabbing that person outside of the courtroom and putting them back in. And some of these incidences are the very incidences that force Ugandans to lose faith in their constitution. What is it that can be done? What is it more than...
Well, you know, when I say teething problems, I am not necessarily minimizing them to say that teething problems cannot be major. You usually will have people in charge of security. They think that someone they have arrested, whom they believe has committed an offense, particularly relating to security, is someone who should be kept behind bars. And those people may not see the value of having this person produced before a court and being detained in a place authorized by law as the Constitution provides. They forget the basis for putting those provisions in the Constitution. The reason why we put those, and that has been my argument before, and I'm saying so now, the argument was, during Idi Amin's time, so many people got to be arrested for offenses we shall never know. We shall never know whether they were guilty or not, because they were never produced before any court. They eventually disappeared. Some totally, like the former Chief Justice, never to be found. So when we were making the Constitution, we were all saying, never again. That was a common phrase when we were making the Constitution. People would say, never again should this happen in Uganda. It was the basis for providing that any person may be arrested if there is reasonable ground to suspect you have committed an offense or you are about to commit an offense. Yes, you can be arrested. But we don't want you to be arrested and disappear. That's why we said you should be produced before a court. Let the power to grant bail be given to a court. And the court may grant or refuse bail. Courts can refuse bail legally, constitutionally. And when they have, and you have to be told why you are being charged. Your next of kin should be informed. Your lawyer should be allowed to see a lawyer. So that we get away from the culture of someone disappearing. That was the basis for those provisions. So what I have seen is those who say, when our people go to court, they get to be released. They get on bail. Therefore, we must not grant, we must not allow bail to be granted. That would take us back. We are looking at a small situation where someone may or may not be granted bail, but the bigger picture was that this should never happen in Uganda again. So that means for trust in the courts, and then it also means that the judge who is hearing the matter exercises his discretion judiciously, so that people can understand why this person has been granted bail and the other one has been denied bail. It is, you can call it a teething problem, but in my experience, it has been one of the areas that we have to keep fighting.
Chief Justice, if we could bank that, the relationship between the judiciary and the security services aside, and the relationship between the judiciary and the civilian authority still, you were on the Supreme Court bench that listened to the amicus curiae matter at the Supreme Court.
Yes.
These were distinguished professors of the law who came to the court. They were not part of an electoral contest. They felt that there were changes to an electoral process that were required to make that electoral process fair. And despite the Supreme Court being very elaborate on what reform should be carried out, the timing, and even in putting in your own judgment that you should report back to us every 6 months, the Attorney General didn't do that, neither did the Ministry of Justice and Constitutional Affairs. These are both offices that you've occupied at some point, so you would know the politics in something like that. Why would civilian authority be resistant to judicial power?
These were recommendations. First of all, when you talk of amicus curiae, I think it was the first time that we as a court decided, there were many people opposed to it. You can't allow these people from Makerere to give, no, why not? Let them give us a guideline. And I think we benefited from their opinion. So they brought up something called a structural interdict, where you can say, please do the following as a recommendation to government. Because we can't enforce our recommendation. The recommendation is not part of the decision. It's a recommendation. Why the recommendation was not respected? I think this is part of the failure to develop a culture of constitutionalism, to say, yes, this was a recommendation from the highest court, it should be treated with the highest respect it deserves. I think there were attempts. I remember we had even at one time someone, the Attorney General, to explain. I think they made some bills. They brought some amendment bills in Parliament. I don't know how far they went with that. In other words, they were saying, we are doing it. We are bringing up the bills as recommended. How far they went, I really don't know. But what we need is to build that culture, that even where you have a structural interdict, where recommendation, it should be given the respect and the attention that it deserves. If it can't be done, you can say it can't be done. So I don't know why they didn't do that.
But so what would the judiciary do to enforce a culture of constitutionalism? Because in for example, electoral competition, every time we get into an election, many Ugandans, myself inclusive, feel the country is tearing at the seams over what should be a very polite political competition to produce who the leader of the country should be. What should the judiciary do to enforce that constitutionalism so that many Ugandans feel bound by this constitution?
I don't know how you can enforce constitutionalism. It is a culture that has to be built over time, and not only by one branch of government, not even just by the branches of government, but by all of us. That if I lose, I go to court, I get a decision which I respect. If I lose in the court, I appeal to the next level of court. And indeed, I'm sure you have seen in many of the petitions, said, especially at the High Court level, people win at the High Court, they get overturned at the Court of Appeal, where it stops. So it is not the judiciary enforcing. What we have to do as a judiciary is to ensure that when the case is brought, it is heard in open court, fairly, all the evidence is in, the witnesses are examined openly, and you make a reasoned decision. Now, a reasoned decision does not mean it will be accepted by everybody. There are many people who will say you didn't take this into account or this into account and so on. But it must be a decision that you say, this is my decision and these are the reasons for it. When you create transparency in the judiciary and the way decisions are made, you are actually enforcing constitutionalism in as far as the making of decisions is concerned. The larger problem, though, is that in Uganda, there was a study by the Hague Institute for Legal Innovation in 98, I think, 98 or 2008, which found that in Uganda, out of 100% of people who have a justice need, who need to get a resolution obtained in court, only 5% have access to a formal court system. 5%. So when you talk of the culture of constitutionalism in the judiciary, you can see how big the problem is. To get even the ordinary person everywhere in Uganda to have access to the formal court system. And there are reasons for that, which probably we can't go into it. And then of that 5%, only 2 or 3% have access to lawyers. So you have lawyers, we think there are too many lawyers, but the public, the many people in Uganda don't access them. So they don't access the lawyers, they don't access the formal court system. Now, one of the things that I tried to do when I was there was to try and have a day, each court have what we call an open day at its premises, and usually a Friday. Have an open day when the what do you call them? These people who have cases in court may come, not hear cases, but sit in a baraza, and the judicial officer in charge of that court, whether it's a high court judge or the chief magistrate, will address these people as to what the court does. What does this court do? How can one apply for bail? What does it mean when your case is dismissed or when your case is adjourned and so on? All the procedures of court. Usually we also have the Department of Prosecutions there. We have the police there. They also exhibit a stand on what they do. We try to do that as a way of getting people to start appreciating. And it was gratifying to see how many people turned up at these barazas. And I attended quite a number myself. And then we allow people to ask questions. And it was very revealing how much people know and don't know. And sometimes people would think, okay, Chief Justice, you have come, so he brings his case, he wants a decision there and then. He does not understand that you are dealing with this to educate him how this can happen. But even that, you give that explanation. So that, together with all the other outreach programs that the Judiciary has been doing, is the way we can try to reach people. And as long as people can reach the formal judicial system, as long as they can have access to their lawyers, who can explain to their clients how these matters can be handled, we will get there. But it is still a big problem. We have a judicial system which is only now beginning to roll out. Because you can imagine in a region, let's say in Gulu, if you found that there was only a high court at Gulu with only 2 judges or even 1 judge, and that deals with the whole of the actual sub-region, and you come and you find 1 judge in the Lira, and you go to Mbarara, you find 1 judge or 2, and the next judge is in Fort Portal, and there is no judge in Kabale. You can imagine, because if the country could stay, the whole of Uganda, with a population of 45 million plus, you have only about 50 judges at the High Court level. You are supposed to have 300 chief magistrates, you have less than 100. It becomes now a problem of even how to reach. But I'm happy to note that ever since I left, after the passing of the administration of the judiciary law, which created the judicial fund where now the judiciary also has its funds which it can manage, more judges have been appointed, more magistrates have been appointed. So it is a process that will
You did commission, and I'm happy you've spoken about that, but you did commission a study into case backlog.
Yes.
And some cases in the court had been dating back almost a decade at the time that study was done.
Yeah.
At the time you left the helm of the judiciary, the case backlog was still there.
Yes.
Still very strong despite more judges that you had campaigned for. And somebody asks, is it the number of judges? Is it the quality of judgments? Is it judicial laziness?
It's, first of all, let's say this. Every jurisdiction that I know has had a problem of case backlog. And I took the trouble to study, to go out and see what other people have done. Every jurisdiction. It is a question of how it is to be handled. First of all, the case is handled by a judge. A judge is a human being or a magistrate. You can hear so many cases, but cases may not be disposed at the same rate as which they are being filed. Now, I'll give you an example that at one time in the commercial court, they had over about 5,000 cases, and there were only 4 judges there. In the land division, they had over 10,000 cases, and at that time I think there were only 3 or 4 judges there. If you divided those cases and gave the judge to do a case every single day finish a case and write a judgment, assuming that was possible, in a year, including Christmas and public holidays, a judge would write 365 judgments, finish 365 judgments. So if you have 1,000 cases on your desk, how many years would it take you to write those? Now that's something that usually is lost on people when they say judges are not working. Judges are working. That's why numbers become important. Before I get to the question of the quality and so on, you have to have a critical mass. Parliament had passed a resolution to increase the number of judges from 45, 50 to 82. This was the number that Parliament had given us about 5 years ago. As I speak now, I think it is they are about to reach there. I think they have now reached 72. So even when Parliament had seen the need to increase the number, the Treasury was always saying there's not enough money. But now that the money has been given, that's why you are having more. And I'm sure you will see that there will be. Even the magistrates, more magistrates are being appointed. They are created more magisterial areas. So I think that is going to have an impact. Now, when it comes to the quality, because we must not just say, sit here and produce judgments, there must be quality judgments. That, first of all, goes to the quality of the people you make judges. Someone must have the capacity to read, to study, to listen to the arguments, to read the law, and to be able to write a decision, a reasoned decision. Because the quality of decision is not necessarily one you agree with. You can have a judgment you don't agree with, but you say, okay, but the judge, I can understand his reason, but I don't agree with him. So this one is with a little bit of experience and a bit of training. Judicial training is a must. All the countries I visited, there is always judicial training.
Chief Justice Emeritus, again, on the quality of judgments, there's a creeping problem in the judiciary, and these are cases which have even been at the Law Council. Lawyers intermittently complaining that lawyers on the bench arguing cases are writing judgments for judges, and the judges are writing their names, they are penning their names on it.
That should never happen.
The judges are writing their names, they are penning their names on it.
That one would be a case of gross misconduct, gross incompetence, which, if duly investigated and found out, that judicial officer should be removed. It's just ethical. It's just stealing. You cannot sit as a judge and ask one of the parties to write the judgment for you. Then you are not a judge. You are not a judge at that point when you are signing for that judgment. You are not a judge. You are a merchant, maybe, who has sold justice. So the Judicial Service Commission, the Law Society, the Law Council, and you, the lawyers practicing, should have your ears out there so that when this type of case is reported, it is properly investigated, and if found true, that person should be removed from the bench. It's not a question of people write judgments for when they shouldn't. No.
But another ethical bleach that affects the judiciary and the perception of the judiciary. More recently, 2 months ago, a magistrate appointed, about to take oath, was found writing a low-class paper for someone at LDC for 5 million shillings. That undermines the perception of the judiciary in general.
It shouldn't. We are having so many people, criminals, entering our systems. You are having people without academic papers entering parliament, and they have to be disqualified by judges. You are having people stealing money when they shouldn't. So someone who has just been appointed, a magistrate, going to write a paper for someone else is similar to the person I've just told you, who is going to put his signature to a judgment written by somebody else. And that's criminal, and it should not be taken as a general rule. In my time, when I was serving on the Judicial Service Commission as a representative of the judiciary, before that I had served as chairman of the management committee of the Law Development Center. And at one time, someone applied to be a magistrate, and he presented his documents to us for an interview. And I was there interviewing this fellow. He presented a diploma, a postgraduate diploma in law as his qualification for his Law Development Center. And as you know, the Law Development Center does not issue a postgraduate diploma in law. They issue a postgraduate diploma in legal practice. And you could see even the format of it was wrong. And to make matters worse, those certificates are signed by the chairman of the management committee. And it was signed by the chairman management committee, Bart Katureebe. At the time when I had ceased to be chairman of the management committee 2 or 3 years before. So we interviewed this person, asked him, until he himself said, I think there's a problem with my certificate. And then we found actually he had been dismissed from LDC a long time before. But he had gone to Nasser Street and got a diploma for which he was trying to join. So those cases are there, and the responsibility is to weed them out. And that's why even the Constitution provides for removal of judges. But the removal has been protected in the sense that you cannot have malicious allegations on the basis of which to remove a judge, to protection for their security of tenure. But that is not a guarantee for not taking action where there is need to take action. But so it is anticipated. There may be misbehavior, there may be incompetence. It's provided for. It can be removed. And because one judge has been dismissed or been removed or been caught stealing, does not mean that the whole judiciary is.
The whole bench. Chief Justice, and this now goes to your legacy, and you write about this in the book. If we were to write your legacy and say, which parts of your legacy would make your legacy strong before you pass on? And one of those is the Constitution that you've given this country. Do you feel or agree with the people that say we need a constitutional review of the 1995 Constitution to make it stronger as a document?
I think now, it's how many years since we made the Constitution?
It's almost 30 years.
It's almost 30 years. There have been some amendments to the Constitution in some fundamental way, others would argue. There have been calls for others. Because, for example, one of the areas when I was Attorney General that I had to contend with was some people wanting to remove this requirement for somebody being produced within 48 hours before a court, especially in terms of security. People say there's not enough time. And we are not the only people who have had this type of problems. I think in the wake of the terrorism menace, even in Europe, even in Britain and so on, they amended their laws. In America, they had something called the Patriot Act and so on. So there was that. We resisted it to say, this Constitution has just been made. We haven't tried it yet. Let's try it. But you still hear these calls for that period to be expanded. Maybe it is time we had a debate about this and see whether it can work and what is the best way it can work. That's one example. So if the Constitution has been in operation 30 years plus, having a team to review, to look back on it and see what has worked and what has not worked. If it has not worked, why has it not worked? Why is it being challenged? If it has been amended, have the amendments produced the desired results, or they have undermined the very spirit and essence of the Constitution? So yes, I would have no problem with having a strong team looking at the Constitution, because the Constitution, as I said, is a living document. It provides for its amendment and growth and so on, as the situation changed from 1995 when the Constitution was. And many people may still say, no, the same thing still obtain. The mischief which was meant to be cured by this provision is still there, so we still need it, maybe even to strengthen it. Maybe the provisions we put there were too weak. For example, when the amendment was made on the term limits, I think many people have come around to say, we wish we had strengthened it by making it double entrenched. But it hadn't been double entrenched, which meant Parliament could amend it. And they did. Someone may now say, maybe we better go back to that provision and make it double entrenched. Maybe even not only requiring 2/3 in Parliament, but maybe even requiring local councils as well. So yes, there is reason to support a review.
Would you say that that Constitution that you are proud of in 1995, that you have pictures of even in your book, would you say it maintains the same basic structure when you made it?
I think it has maintained the basic structure. There may have been some violations There may have been some disagreements as to what has been done and so on. I think there's, depending on what you understand as the basic structure, I think it, in the main, still maintains the principle that the authority of government, the sovereignty is vested with the people. Who shall be ruled in accordance with the Constitution. There's establishment of an executive. And there is a provision in that Article 99, which many people sometimes don't quote correctly. They say the executive authority of the government has been of the state has been vested in the president. It doesn't stop there. The sentence goes further to say, who shall exercise it in accordance with the law and the Constitution. So this is where you would now be saying, yes, the executive authority is still vested in the executive. It is still necessary that the executive authority should be vested in the executive. You can now say, looking at the experience, has it been exercised in accordance with the law and the Constitution? And then you can try to argue around that and add or subtract. Then you can say judicial power has been vested in the judiciary. But it also says the judiciary who shall bear in mind when they are making decisions the norms, the aspirations, and so on of the people of Uganda. What does that mean? And the principles that have been given there. Then the legislative power has been given to the parliament and oversight of government. And then you can ask, in terms of the Constitution, has parliament performed its role? In terms of the Constitution, has the judiciary performed its role? Are there weaknesses where it should be strengthened? Are there strong points which should be maintained? So the basic structure, as far as I'm concerned, is there. And you need to maybe to add or subtract from what has been done.
But when we see the overarching influence of the executive in the judiciary, for example, appointment of judges, appointment even of the Chief Justice is done by the executive, the president in this regard. When we see the executive's authority over the legislature, lecturing members of parliament, threatening at some point to do away with the Constitution if parliament does not agree with the executive, that overarching influence gives us the impression on this side that this Constitution, even in design, gives the executive such overarching influence, and the executive is vested into this one individual in whom now all hopes and aspirations of Ugandans should be. It might also explain why a lot of competition exists at the presidency. Wouldn't you say that you need to plug those gaps and reduce that competition?
Well, first of all, I see this argument, the president appoints judges. I would like to hear someone say, who should appoint the judges? Or if you appoint judges, does that necessarily mean the judges are yours? What has been the practice before? What's the practice in the neighboring countries, for example? What's the practice in America? What's the practice elsewhere? Who appoints judges? Because somebody must appoint judges. You may wish to take the route, as they do in some states in America, that judges at a certain level, at state level, may be elected. So you go and campaign and you are elected. Now, how does it feel when you have been elected on one party stand, and you have got somebody of the opposite party coming before you? Maybe it works for them. So I would like somebody to do a proper study there. My take, and I'm speaking from my own perception and experience, simply because someone appointed me a judge does not make me part of his structure. Because there are such guarantees in the Constitution for your independence that you can make a decision that somebody may not like. The only problem has been there will be an assumption, even by somebody, maybe who was appointed, that since I appointed him, he should be ruling for me. And also the assumption by the other side that since he was appointed by this one, therefore whenever he gives a judgment, I don't need to read the reasons for his judgment. It must be because of the other, which is all wrong. I think the independence which is given to judges in the judiciary, if you appoint the right people, they can live with the provisions of the Constitution. Look at the alternatives. I think in Kenya they tried open method and so on, but you remember at one time they had a deputy chief justice who had been openly vetted and people brought up even her personal life and so on. But 6 months down the road, she was removed. So I don't know whether you would also like your judges, because someone has applied to be a judge, he comes there, and all his personal issues and so on are put there for people who want to make fun and so on. Is that the dignity you want to give to your judges? I don't know. But this assumption that because so-and-so was appointed by the president, therefore can't be an independent judge. Okay, I would like to listen to other suggestions.
Okay, if we take away appointment and still keep appointment within executive power, progress within the judiciary, if you want to progress from the High Court to the Court of Appeal or Constitutional Court, or from there to the Supreme Court, that progress is still very much tied down to executive power. And some people, maybe even rightly so, say the behavior of judges in the lower courts determines whether you can go up or not.
How do
you address that?
I don't know about that, because at the higher court, the Judicial Service Commission has developed a system where now people apply. You apply and you are called for an interview. And then names are sent to State House. And from there they go to Parliament. So it's a question of whether State House is exercising its authority properly, or whether Parliament is exercising its oversight. Because Parliament has the power to say, this person who has been recommended for appointment, we don't think is the right person for the reasons they can give. And the reason we put those checks and balances was specifically to address the question you are saying. If someone has been a judge of the High Court for 2 years and is being recommended to go to the Court of Appeal, and there is somebody on the Court of Appeal who has been there 10 years, somebody somewhere at the third vetting point should say, why this and not the other? What is the reason for that accelerated promotion? So the checks are there. They may not be being implemented, but the checks were there deliberately for that, you know. So it's, I think at the High Court level, people are applying. There has been a debate of people who are serving judicial officers, magistrates, registrars, and they are asked, they have been arguing, they call themselves sitting tenants. They are saying, if I joined the judiciary as a magistrate, and I've been a magistrate 15 years, what is my way forward? How do I access the higher bench? You know? So why should you bring a lawyer from private practice, make him a judge? And me who has been in the judiciary 15 years, I don't get that promotion. So that debate has been there, and I think the Judicial Service Commission has been trying to balance that. So you have seen now they are appointing people from among the serving registrars and chief magistrates, and also from private practice. So those are things now of implementation. But I see no big problem there.
Chief Justice, now very finally into your legacy. When you see the level of contestation in society, the undertones that cause anger, the income inequalities that people talk about, the rampant abuse of law by people vested with power, given that power by the Constitution. When you see those things, what do you say to yourself and to Uganda?
For me, I have no qualms. I don't belong to the class of people who think that just because we made a constitution, so suddenly everything in Uganda goes very well. The contestations you are talking about, the contradictions you are talking about, I think are inevitable in any society. There's nothing that is happening in Uganda that should not have been anticipated by anyone. The corruption, the greed for power, people going to parliament with forged certificates, people going to parliament, sign for money and never appear in parliament. Those are contradictions. Yet when you are standing out there, you are saying, I'm going to work for my people. I'm coming to consult you on everything. Many people you have had their constituents say, we have never seen you again until the next election. The corruption. Now, the corruption is, I think, unprecedented levels. Unprecedented levels, why? Maybe there has been lax in law enforcement, in investigation, because it's not enough to say so and so has stolen. You must have the capacity. The IGG must have the capacity to investigate and bring whoever is charged with that offense. Now, but if you don't have that capacity, then somebody will walk away. And people have even put it in another argument. We have this adversarial system. You have been accused of a criminal offense, like bribery or stealing. It must be proved beyond a reasonable doubt. That's the law. That's the Constitution. You must be presumed innocent. Someone who is charging you must prove your guilt beyond a reasonable doubt. And I have read a paper where someone says a clever prosecutor can actually hang an innocent person who doesn't know the law, who doesn't have a clever lawyer, who doesn't know how to defend himself, can actually be hanged for a crime he didn't commit. Likewise, a clever lawyer can get off a guilty person from being convicted. Now, that's the law we want. That's the Constitution we have, presumption of innocence. Now, are you going to say, because so-and-so, whom we believed was guilty, yet the court found him innocent, we should abolish the presumption of innocence? At what cost will that be in terms of long-term benefit for society? So those are the sort of issues that will have to be looked at. For me, I think it's not a big problem. It should be anticipated. There are contradictions in society. We look at America right now, and the whole president comes and says our election was a fraud. And suppose the attack on Congress at the Capitol here had happened, say, in a country like Uganda or Kenya, what would have been the reaction of most people across the world? It just shows you that in human society, there are occasions will arise when such contradictions come up. The challenge is to have institutions built and strong enough to withstand those tremors, so that, like in America, people can attack, but the institution survives, and the people who did it are now being tried. But you can't stop them trying. So likewise, people here, we must build our institutions which will get rid of corruption by prosecuting people, by finding the evidence. We must get rid of our institutions like Judicial Service Commission to look out for those judicial officers who are tainting the name of the judiciary. I don't mind if the judge gives a judgment that I don't agree with, but sign a judgment he has not written, which has been written for him by one side. That one should not even be sitting there as a judge. They must find a way of removing him. So these contradictions, if you are hoping to have a constitution which will work flawlessly, the moment you sign it, no more corruption, no more contradictions, no more people trying to become judges when they shouldn't be, then you are talking over a utopia that may be difficult to reach.
But you say this calmly, but when those contradictions reach, for example, at the apex of the judiciary, like we saw at the Supreme Court, the exchange between a Supreme Court judge, the Chief Justice, and the Permanent Secretary, when the contradictions are at that high level, it gives a sense of worry.
No, why?
Gives a definite sense of worry.
Why? That there are three individuals at the apex, and they disagreed on a matter and behaved differently to it. Why should that be? Those contradictions, I found them there. I think I had some experience of it. Handled it differently. So that's not, the judiciary is there. You remember there was a time when there was a big problem between the then Chief Justice and the principal judge? Did that destroy the judiciary? The judiciary is still there. There has been these reported disagreements between a judge and the Chief Justice. I think eventually it will be resolved, and the judiciary goes on. How can you do away with? They are all over the world. there are people who don't get along even when they are in the same cabinet or in the same office. And that the important thing is that the institution can withstand that two judges can fight and the institution remains. And that should be the goal. The institutions must be built. And I think that's the big challenge for us as a country, for the government, for all of us, to have our institutions built on a strong foundation so that they can withstand these challenges and shortfalls and contradictions.
Chief Justice, very finally, if you could write a final chapter in your book for your grandchildren, what is the Utopian Uganda for you?
The Utopian Uganda?
Yes.
The Utopia Uganda is where I can live in the village in Bunyaruguru in peace. I go to send my children, they go to school and they find the necessary tools for learning there, teachers, books, and so on. I fall sick, I go to my health center and I find medicine is there. When my children finish school, they are able to get gainful employment somewhere. And I don't have to worry that someone is going to change government at midnight, but I will vote for my leaders and I will vote for my MP, I will vote for my president or whoever will be the description, and I live peacefully. And I don't have to worry about someone coming to arrest me in the middle of the night for unknown causes. The sort of things we knew before, the sort of things that we are trying to fight now, in a utopian Uganda, should be where someone lives in peace and gets what is entitled to get as a citizen and contributes his contribution as a citizen. He pays his taxes, he does a useful, gainful work, all the duties we put in the constitution of a citizen. If I carry out my duties, then I expect the state to equally carry out its duties towards me. That's the utopian Uganda.
All right. Thank you so much for speaking to us, Chief Justice.
Thank you.
We've been speaking to the Chief Justice Emeritus of Uganda, Bart Katureebe, at his home here in Bugolobi, and it's been such an interesting conversation. Thank you so much for watching and have yourselves a good day.